I welcome you on behalf of the Vis Moot directors to the final round of the 28th Willem International Commercial Arbitration Moot. It is the second virtual Vis Moot in the history of the Moot. We made it again. Since the Moot started last Saturday, we conducted about 840 remote hearings in 5.5 days. Thanks to the IDRC, Damien Hickman and his amazing team of room managers who did a marvelous job in guiding our space shuttle across the Nubia and Vindobona. 380 teams participated in the oral hearings. Congrats to all of the students and also to the 1,200 arbitrators that brilliantly managed the techniques. Although everyone was set in a total different part of the world, I think it worked out pretty well. Today, this final round is live streamed. I hope the audience is well settled in front of the screens and have it relaxed. The results of this session and the announcement of the awards will take place later on in the closing ceremony at 3:30 Vienna time, PM. This event will then also be live streamed. It's now my pleasure to introduce you to the final panel and the teams today. The panel will be chaired by Gabriele Natabas. She's based in Zurich and a partner in the litigation and arbitration team of the law firm Homburger. She's well known in the arbitration community. She's well known for her expertise as arbitrator and counsel in commercial arbitrations, investment treaty arbitrations, and complex cross-border litigations. She served as the president of the arbitration court of the Swiss Chambers arbitration institution SCAI, whose rules are being used in this year's moot problem. She's also a board member of various arbitral institutions and co-chairs the ICA ASIL task force on damages in international arbitration. She's also a member of the steering committee of the Equal Representation in Arbitration Pledge. The second arbitrator that we welcome is Anne Ryan Robertson. She's the global president of the Chartered Institute of Arbitrators. Anne is an international partner in the Houston-based office of Lock Lord. She's known for her long-standing experience as arbitrator and counsel in complex international business disputes. She's a member of many arbitral institutional panels, including the ICDR, the Hong Kong International Arbitration Center, KCAB, and many more. The third arbitrator is Professor Lauro de Gama. He's adjunct professor at the Pontifical Catholic University of Rio de Janeiro, where he teaches private international law, contracts, and international commercial arbitration. He's a member of the CISG Advisory Council. Professor da Gama is an experienced counsel and arbitrator and also served as president of the Brazilian Arbitration Committee. He's currently a member of the ICC Court of International Arbitration. I also welcome the two teams that advanced to this final round. They are Putzerius Law School team representing claimant today. The speakers are Ms. Manjedi Leek. She will do the procedure. Mr. Jonas Klein, the merits. Welcome also to the Singapore Management University team, representing respondent in the arbitration. Ms. Lo Chiana will do the procedure and Mr. Robbie Tans, the merits. I will now hand over to the presiding arbitrator and wish you all an enjoyable session. Good luck to the teams. Thank you.
Thank you, Patricia. Yeah, I'm not on mute. Also, on behalf of the Arbitral Tribunal, I would like to welcome you to this oral hearing in the SCAI arbitration number 300610-2020, Respivac PLC versus Comveer Ltd and Vector Veer Ltd. As you have heard, my name is Gabriele Natabas. I'm the presiding arbitrator, sitting here together with my co-arbitrator, Ms. Anne Ryan Robertson and Professor Dr. Lauro de Gama. As you're all aware and have heard, these arbitration proceedings are governed by the Swiss rules. And in the procedural order number 1, it was agreed together with the parties that in the first phase of these arbitrations, 4 legal questions shall be addressed by the parties, 2 procedural ones and 2 merits questions. Having received the first round of memoranda, we are here together today for a further round of oral pleadings on these 4 topics. For this oral hearing, this arbitral tribunal has done some deliberations to come up with a proposal how to efficiently structure this oral hearing. The tribunal has decided that it would like to structure the hearing as follows. It would like respondent to start with the procedural issues, followed then by claimant, and then we would go on to the merit questions, which would be started by claimant, followed by respondent. Each side will be provided with 12 minutes pleading time, followed by a 4 minutes rebuttal time and 4 minutes SOR rebuttal time. Let me know if you have any questions with regard to the sequence and the structuring of the hearing.
No questions from the claimant side. Thank you very much.
Thank you. From respondent side?
No questions from the respondents. Thank you very much.
Okay. You shall be aware that the SOR rebuttal should be in principle strictly limited to the rebuttal statements. Of course, if there are reasoned objections or reasoned reasons raised why we should make an exception, we will certainly consider that. The arbitral tribunal may interrupt any time for questions, and this is as it is per the usual practice. So if there are no further housekeeping rules, I think we could start with respondent, and it is my understanding here that we do have Ms. Lonchana. Please let me know if I don't pronounce your name correctly.
It's not a bus, it is Loziana, but I understand, and I'm also not sure if I'm pronouncing your name correctly.
You absolutely correctly pronounce it. So if it's okay, I would refer to you as Miss No. That's for me the easiest.
Yes, thank you.
Perfect. So the floor is yours, and you may start with the procedural arguments.
Thank you very much. Members of the tribunal, good evening from Singapore. My name is Lo Jiana, and together with my co-counsel, Mr. Robbie Tan, I appear on behalf of the respondents, Canva and Vectorva Limited. Members of the tribunal, the dispute before this tribunal concerns the potentially conflicting rights of licensees to the Gore-Adcam viral vectors. The licensees here are the claimant and Ross Pharmaceuticals, while the licensors are our clients. To complete the picture and put the dispute in its broader context, our clients have proposed joinder of Ross Pharmaceuticals. This is particularly because claimant, in commencing proceedings, has relied on Ross's potentially conflicting right. Yet, confusingly, the claimants are resisting joinder. Against this backdrop, I make 2 submissions. First, that joinder of Ross Pharmaceuticals should be allowed, and second, that a fully remote hearing should not be allowed for the evidence taking. Turning to the first issue on joinder, here, if I could refer members of the tribunal to page 16 of the record, this would be the Purchase, Collaboration and Licensing Agreement, or PCLA, as between the claimant and the first respondent. At page 16, members of the tribunal, in the middle of the page is clause 14.1, and it states, in the first paragraph, 3rd line, that the Swiss institutional rules apply. And Article 4.2 of the Swiss rules is the relevant joinder provision, and it states that this tribunal shall decide on a request for joinder after, quote, consulting with all of the parties, including the third party to be joined, and taking into account all relevant circumstances. The Swiss rules entails a balancing exercise that takes into account both the objections of any parties, as well as the relevant circumstances. And here we acknowledge that claimant and Ross Pharmaceuticals have raised objections. However, our argument for joinder here is twofold. First, to prevent the risk of conflicting decisions, and second, the objections by claimant and Ross Pharmaceuticals are not fatal.
Excuse me, Ms. Dunn, can I quickly ask you, why would it be a problem for this tribunal to have conflicting awards?
Certainly, Ms. Notter-Bus. Here, we would refer this tribunal to the notice of arbitration at page 8, paragraph 26. This would show the basis that the claimant had brought present proceedings, which is because the use of the GORADCAM vectors may be, and I quote, potentially restricted by an IP right of Ross Pharmaceuticals. So this potential overlap between the two licenses forms a crucial part of this tribunal's inquiry. If this tribunal were to rule on whether the claimant can get a declaration for breach, it would have to make a finding as to whether Ross's claim is completely baseless or has some merits to it. And this would give rise to a subsequent conflicting decision if Ross is not joined and a subsequent tribunal then rules differently.
Oh, sorry, Anne, please go ahead. First.
Please.
No, please.
I want to take this one little, a different step for me. Let's assume that we don't grant joinder.
Mhm.
Let's assume that there are two separate arbitrations then. And let's assume that the second tribunal, which I will call the Ross arbitration, makes a decision on whether or not there is in fact a claim for purposes of Article 42. Can you take that decision of the Ross arbitration and bring it to this tribunal? May we consider what the Ross tribunal determines?
Well, Ms. Robertson, we would say that it would definitely be a relevant consideration, although it may not strictly be binding on the tribunal. However, here the risk we are highlighting is that if there are two such separate awards, then the respondents are put in a position where they may be unable to comply with one award without being in breach of the other. And so this is the risk that we are highlighting. And importantly, we must highlight that we are seeking to bring and to refrain Ross from making such allegations. And insofar as we are seeking this, it is our client's position is indeed aligned with the claimant's interest, because then Ross would be conclusively prevented from bringing such allegations or claims against the claimant. Now, at this juncture, we would note that perhaps this tribunal may be concerned with the objections raised by claimant and Ross Pharmaceuticals. However, importantly, we must consider that parties, as sophisticated, legally advised parties, have agreed to the Swiss rules, and the Swiss rules are distinguishable from other institutional rules. This is particularly if we compare it to other rules such as the SIAC rules under Rule 7 or the HKIAC rules under Article 27.1, which both require express consent of all parties. Here, the Swiss rule states that the tribunal is to consult and consider all relevant circumstances, and as highlighted, the relevant circumstance of the risk of conflicting decisions, as well as the claimant's potential interest in making Ross Pharmaceuticals refrain from bringing such claims, would be highly relevant and militate in favor of joinder.
Mm-hmm.
May I ask you a question, please? Ms. Lowe, how can the Swiss rules or the agreement to apply the Swiss rules replace Ross Pharma's and the claimant's consent in the case at hand in regard to the joinder of a third party who is not a signatory to the original arbitration agreement? Could you develop on that, please?
Mr. Gama, here we do note, Professor Gama, apologies, we do note that there may be two limbs to this answer. First, what is the consent that has been met here, as well as the problem that Ross is not a signatory. In terms of consent, we say that parties have consented to the joinder mechanism under the Swiss rules. So this is not to say that Ross's objections are ignored, but they have submitted to this tribunal's discretion, and taking into account their objections as well as the other relevant circumstances as highlighted, we say that that the balance militates in favor of joinder. And as to whether the issue of yes, Ms. Nottervers, is there a question?
Yes, I'm still struggling, with the balance of the interest test, because I understand that you want to prevent conflicting interest, but understanding that Ross is not consenting to be joined, don't we have to balance that very carefully against the potential of a non-enforceability of an award where Ross is joined?
Yes, if I may take Ms. Nottervers' question together with Professor Gama's question, as they both relate to jurisdiction over Ross Pharmaceuticals. Here we say that there is likely to be jurisdiction over Ross Pharmaceuticals on the basis of their implied consent. And to this, we would point to the agreement to the joinder mechanism under the Swiss rules, together with the fact that Ross is not just any third party, but a third party to an identical arbitration agreement contained in a contract on the same subject matter of the GORAD-CAM viral vectors, such that it would have been foreseeable that disputes as to the scope of this license may be called into question in the future. And members of the tribunal, in light of the time, I move to the second submission on a remote hearing.
Of course.
Here, we say that if an in-person hearing is not possible, this tribunal should delay proceedings as opposed to order a remote hearing. We recognize that in this day and age, many processes are moving online, such as hearings, as we are present in this present hearing. However, in the arbitral proceedings for the evidence taking, this tribunal must ultimately consider what parties have agreed upon, as well as any genuine concerns that parties may raise. Here, our argument is twofold. First, parties' agreement precludes a remote hearing. And second, even if this tribunal considers the possibility of a remote hearing, the relevant circumstances militates against the grant of a remote hearing. On the parties' agreement, yes, Ms. Nottervers.
No, please go ahead first.
Certainly. If I could again refer this tribunal to clause 14, It is found on page 16, the same clause. We note that this clause adopts the model arbitration clause of the Swiss rules. However, at the third paragraph, the second line, this particular sentence was a deliberate insertion by parties, and it stipulates hearings shall be held at the arbitral tribunal's discretion, either in Vindobona or in the city where the respondent has its place of business. Parties have gone beyond stipulating. Yes, Ms. Nottervers, is there a question?
Yeah, you don't have to always stop when you see that I'm actually eager to pose a questions. I will interrupt you when I deem fit so that you are not always taken out of the flow. But in fact, I do have a question because I think you are stepping over an important part of the analysis, and that is, can you tell me on which basis you interpreted this arbitration agreement? Because, I mean, I read, of course, what you have read to us as well, but that must not certainly follow to a conclusion as you are drawing it on the basis of this arbitration agreement.
Yes, Ms. Nottervers. Here we would refer to the UNIDROIT principles, in particular Article 4.1, Section 1, Section 2, apologies, that if an intention can have reference to what reasonable persons of the same kind as the parties would give to it in the same circumstances. And here we say that a reasonable person looking at clause 14.1 would see that there was no distinction between physical hearings and remote hearings on the wording of clause 14.1. And so it must have been intended to govern hearings as a whole to be held in person. Now, even if this tribunal takes a more flexible interpretation and considers the relevant circumstances, such as the current pandemic situation, we say that the relevant circumstances militates against a fully remote hearing. In particular, we would raise the issue of cross-examination of witnesses. Where extensive examination of witnesses is involved, a remote hearing may pose the risk of any technical difficulties arising or lags over a video conferencing platform, and this may inadvertently give the wrong impression when the witnesses are being cross-examined. And so this, amongst other logistical issues, makes remote hearings not an ideal alternative. And
But
as of the
Ms.
tribunal,
Now, wouldn't you agree that hearing witnesses remotely has always been practiced for many various reasons, and that I'm hardly aware of arbitration cases where this truly has led to a problem, maybe to interruptions, of course, maybe to resumptions of hearings at a later stage upon technical issues taken care of. But can you elaborate further? Because I do think, let's also take the pandemic situation into consideration. Reading witnesses with a mask on, and I think that would be a necessity today, may also not be that easy. So I'm really questioning whether the fact to have a witness present in front of you has that many advantages.
Ms.
Mr.
Lauterbach,
Chairman, I would just like to follow up on what you have just said, just to highlight that their timing is about over, so that she should elaborate and then come to a close.
Good. Thank you. I very much appreciate. He's our timekeeper.
yes, indeed, members of the tribunal. Well, we would say that the present proceedings for evidence taking are different in terms of the extensive reliance of the respondents in particular on the examination of witnesses as compared to the claimant, and that an in-person hearing may be possible in light of the evolving situation with vaccines as well as air travel being on the horizon. And this brings me to the end of my submissions. Thank you very much.
Thank you very much. So I hand over to claimant, and I understand here we do have Ms. Leek, starting with the procedural.
Excuse me, may I pose a question to the respondent before we go to the claimant?
Sure.
Ms. Lowe, let's assume that the tribunal agrees that there will be joinder. What will be the alignment of the parties? In other words, what will be Ross's role in the arbitration?
Ms. Robertson, here we would join the Ross Pharmaceuticals as a third respondent, and however, the relief being sought against them would be an injunction for them to refrain from making allegations as to their claims over the license. Thank you very much.
So are they in essence a third party respondent, or are they
Yes.
a co-respondent?
They would be a third party respondent, Ms. Robertson.
Thank you, Ms. Lowe. That's all I have. Thank you.
Laura, any additional questions? If not,
No
I will
further
move to
questions.
claimant. Good, thank you.
Thank you.
In the essence of time. Good, the floor is yours. Ms. Leek, please start.
Thank you very much. Honorable members of the tribunal, esteemed colleagues, before jumping into the two procedural issues that claimant, just like opposing counsel, would like to address, let me paint a different picture on these proceedings. Claimant is at the verge of commercializing a vaccine against COVID-19 and is thus in desperate need of fast and efficient legal certainty, specifically with regard to its financial recourse against respondent number 1, its contractual partner. In light of this, the claimant makes the two following procedural submissions. First, that this tribunal should not order for the joinder of Ross Pharmaceuticals, and second, that this tribunal should order for remote witness and expert examination. Coming to the first issue, claimant's submission is twofold. First of all, contrary to the respondent's submission, this tribunal does not have jurisdiction over Ross Pharmaceuticals as the non-signatory in these proceedings, and thus cannot exercise its power under Article 4, Paragraph 2 of the Swiss rules. And second, that even if this tribunal were to find to have the jurisdiction over Ross, the circumstances under Article 4.2 do not necessitate or weigh in favor of joinder in these proceedings, and thus the tribunal should not order for joinder. Coming to the first submission, the respondents have pointed us at three possible sources for the jurisdiction of this tribunal. First, the choice of the Swiss rules, both in the Ross Agreement and in the PCLA. And second, the identical arbitration agreements contained in these contracts. And last, the sufficient level of connectivity between the contracts parties and disputes, specifically given the subject matter of GORADCAM vectors and licenses on those vectors. However, claimants submit that these three factors cannot suffice to create jurisdiction over Ross. Starting with the first, the choice of the Swiss rules. It is true that Article 4.2 of the Swiss rules does give the tribunal a broad discretion when it comes to the procedural mechanism of joinder. And it was rightly pointed out by the respondents that there's a difference between the jurisdiction of this tribunal and the procedural power to order for joinder under Article 4, paragraph 2. This is also supported by case law, for example, by a ruling also in arbitration under the Swiss rules in the case of Republic of Mozambique versus Credit Suisse in 2020. The mere choice of the Swiss rules may grant the tribunal a procedural power for joinder. However, it cannot suffice to create jurisdiction over a non-signatory, and neither can the identical arbitration agreements. In a ruling of the Chamber of National and International Arbitration of Milan, in a very comparable case also concerned with multiple pharmaceutical companies in connected research projects, identical arbitration agreements were not sufficient to create jurisdiction. And thirdly, the respondents have relied on the identical subject matter of the disputes that would lead to an additional level of connectivity. However,
Ms. Leek, I'm sorry to interrupt you quickly, but you would agree that Ross has actually agreed to arbitrate under the Sky rules, correct?
yes,
And still you're taking the position that it has not consented and also to Article 4.2, at least not impliedly.
claimant does acknowledge that by choosing the entire set of the Swiss rules, Ross has also consented to the general procedural possibility of joinder under Article 4.2. However, this does not extend to creating jurisdiction of a tribunal ruling over a different dispute and not the dispute between respondent number 2 and Ross. If we
Wouldn't you agree that the agreement between claimant and respondent 1 is broad enough to at least have some, let's say, connections and also overlap with the agreement that has been entered into by Ross and respondent 2? And given the fact that we have respondent 2 already in the proceedings, wouldn't that be the natural circumstances you would be looking for?
The basis for the jurisdiction over respondent number 2 in this case is not the connectivity of the contracts or a possible overlap in the procedural rules in the arbitration clauses, but rather the express consent by respondent number 2. And if we look at non-signatories specifically, this express consent is the first source of jurisdiction. A substantive or later source could be the connectivity between the disputes. However, if we compare this case to other cases where jurisdiction was established on the basis of such connectivity, the connectivity is certainly not strong enough. On the basis of connected contracts, jurisdiction was established where both are part of one economic reality, or where the parties had one intent and one economic project that was concerned with both the clauses and the contracts. However, here, the contracts were concluded 5 years apart and are concerned with different research projects merely over the same subject GORAD-CAM vector. That is certainly not sufficient to create a jurisdictional basis over Ross. If this answers your question, I would now move to the circumstances under Article 4, paragraph 2. And the first circumstance that the respondents brought up was the potential risk of conflicting decisions. It is claimant's submission that this risk is actually not a viable threat to this tribunal and is not existent in the present case. It is true that in their notice to arbitration, the claimant has based its claim upon a right or claim of a third party. However, this is a mere restatement of the twofold standard of Article 42 of the CISG that does provide for a breach of contract under both a right or a claim. And the respondents have specifically directed our attention to paragraph 27 on page 8. And if I may also ask the tribunal to follow me to that paragraph once more.
I'm sorry, counsel, what page was that?
That was page 8.
Thank you.
And whilst the respondents have pointed our attention to the first sentence in paragraph 27 of that page, I would now like to quote the second sentence that starts with whether. And if the tribunal is with me, I would start to quote, whether that is actually the case, namely whether there is an overlap in the licensing agreements, as respondent number 2's press release seems to imply, or not, is irrelevant. Already the mere claim of a third party, which is not completely baseless, is sufficient to render the goods non-conforming in the sense of Article 42(1). So to elaborate further on what claimant's intention in these proceedings is, the intention of claimant is to base its merits claim on a third party claim by Ross. And to prevail on the merits with this submission, it is simply not necessary to join Ross to these proceedings. And it is not in conflict with each other if this tribunal makes findings upon a third party claim, and then another tribunal ruling over the dispute between Ross and respondent number 2 makes findings upon the exact scope of the Ross license.
Ms. Leek, I mean, here I have some problems because at the end of the day, we are talking about one license and we are, let's say the parties are in dispute, in particular Ross may have a different view on the scope of that specific license. But at the end of the day, both agreements, the Ross agreement with respondent 2, as well as the agreement claimant has entered into with respondent 1 is about licenses. And about this licenses with regard to the same vector, if you want, that is at the core of this dispute. So how can you say that the outcome of our arbitration would not affect the second arbitration, if there is a second one?
To answer this question, I would like to refer you to the standard of Article 42 of the CISG. And my co-counsel will elaborate further on this. However, the standard is twofold. And the threshold for a third-party claim is not that this claim needs to be 100% justified.
I'm sorry that I interrupt you. I think what I kindly ask you to concentrate on is to stay with the procedural issues that we have on us and just assume, that the merits decision may be different than what you are pleading in this arbitration. And I would be interested in an answer with regard to my question on a purely procedural perspective.
Claimant would acknowledge that there is a procedural overlap in regard to the subject matter of the disputes, namely a license over the GORADCAM vectors. However, this does not affect the tribunal's findings upon this dispute and another tribunal's findings upon the Ross license, because while there may be a connectivity between the subject matters, they are not identical, and thus the issue that this tribunal will rule on is not in conflict with the subsequent tribunal ruling over the Ross license. Rather, the request for joinder sheds light on the true intention of the respondents, which is to kill two birds with one stone by resolving the dispute with claimant and the dispute over their license with Ross in one proceeding at claimant's expense.
I'd like to ask you a question, counsel. Let's assume that we do not grant the request for joinder. Is there any mechanism by which this tribunal can obtain evidence from Ross in this proceeding?
I would like to provide you with a twofold answer for that. First of all, the claimant have presented Mrs. Rosalie Hübner, who is now working for the claimant, but has been working for Ross Pharmaceuticals as a witness. So this may give some insight into the Ross agreement or the negotiation history of that agreement. However, this tribunal does not have the power to oblige now employed persons from Ross or members of Ross's board to be appointed as witnesses, for example. The only mechanism would possibly be to ask a court to oblige some witnesses from Ross to present in these arbitration proceedings, but this would be very burdensome and is not certain whether that will be the case.
And don't we eliminate all those problems if we have a joinder?
In light of time, may I ask for an additional minute to answer your question and briefly touch upon the second issue?
Yes, this is granted. Thank you.
Thank you very much. It is claimant's submission that a joinder is simply not necessitated in these proceedings. And my co-counsel will elaborate on why we can, just on the evidence that we have before us now, prove that there is a third-party claim by Ross. And it is thus not even necessary to appoint witnesses from Ross Pharmaceuticals, and even more so not necessary to join Ross to these proceedings. To move to the second issue, I would pick up on my respondent's opposing counsel's argument that the arbitration agreement actually prohibits this tribunal from ordering for remote hearings. And the respondent's counsel have directed us to page 16 of the record. And whilst it may be true that the parties have stipulated for venues of hearings, we know from the drafting history of that clause that they did not at all discuss virtual hearings. So their intention could not have been to derogate from the broad procedure authority of this tribunal under Article 25, paragraph 4 of the Swiss rules, which specifically allows for remote conduct of the witness examination. And the respondents themselves have pointed at the significant change of circumstances that has happened since the clause was concluded. And this
Ms. Leek, maybe I have to ask you the same question, if you allow me, that I have also asked Respondents' Council. On which basis would you interpret the agreement? Because you are now making your argument also on an interpretation, and you're actually placing it on an actual understanding, saying that they have not discussed the possibility of a virtual hearing.
The standard that claimant would apply is Article 8 of the CISG. As we know from Procedure Order 1, that the CISG can, in the respective countries, also be applied to the interpretation of the arbitration agreement. However, the standard under Article 8 and the standard mentioned by respondents under Article 4 of the UNIDROIT principles are identical, and both take into account the actual intentions of the parties first, before coming to the reasonable person standard. And it is claimant's submission that the actual intentions here show that the parties were not aware of the possibility of remote hearings, or at least did not discuss them.
How can you actually prove an actual understanding on the non-existence of discussions?
If I may direct your tribunal's attention to page 57 of the record in this regard. And specifically to paragraph 32 that is concerned with the drafting history of the arbitration clause. Most of that paragraph is concerned with the draft of that clause in the Ross agreement. However, the last sentence is concerned with the discussions between claimant and respondent number 1. And there it says that the issue of virtual hearings was not discussed by the parties. And thus, the broad power of the tribunal under Article 25(4) remains. To briefly touch upon the circumstances that this tribunal should consider, it is claimant's submission that actually witness tampering is a risk that can be mitigated by technical means, for example, by 360-degree cameras or by obliging a notary public to be present in the room. And furthermore, numerous case law that was rendered during the pandemic, for example, the rulings by the Austrian Supreme Court or the District Court of Illinois, show that in multiple occasions, remote hearings were a viable mean to actually conduct witness examination. And with this, I would conclude my submissions on the procedural issues.
Thank you very much. Any follow-up questions from my co-arbitrators?
Yes, I actually have one. Thank you very much. One of the concerns that I think the tribunal has, in which you can appreciate, is the issue of time differential. How would you suggest that the tribunal address this particular point if, in fact, we agree that this should be a virtual hearing?
I would like to provide you with a twofold answer to that question. First of all, to the practical concern. Claimants would ensure that they are willing to accommodate the time zones of both the tribunal members and the respondents as well as possible. And it would be claimants' proposal that the time slots allocated for each evidentiary hearing would be shortened a bit, so that at the broad border of the business hours, hearings could be conducted and no party would have to stay up for example, a whole night. And furthermore, we must compare the situation of a remote examination with an in-person examination. If the parties would have to travel to Vindobona, specifically the Respondents' Council and the witnesses from Equatoriana would have to endure an 8-hour jet lag that seems certainly more burdensome than standing up outside of business hours to conduct 1 or 2 evidentiary hearings.
Thank you, Counsel.
Any further follow-up questions? Laura?
I have no questions. Thank you very much.
How are we in time?
Yes, they are in time.
Good, very good. I would nonetheless say, as we have addressed many questions with regard to the procedural issues, let's move on to the merits part. And here I understand that, again, it is claimant this time who will start. So we are staying with Claimant's Counsel. And it is this time Mr. Klein who will start. Mr. Klein, the floor is yours.
Thank you very much. Honorable members of this tribunal, esteemed colleagues, I would like to address the merits of this case on behalf of claimant. And to do so, I would like to follow up with my co-counsel and stress once more that claimant is on the verge of commercializing a potentially life-saving vaccine in this global crisis. And therefore, claimant in any event requires unhindered use of the GORADCAM vectors to do so. With respect to the merits of this case, claimant wishes to make two submissions. First, that the purchase collaboration and license agreement is governed by the CISG. And second, that the GORADCAM vectors respondent number 1 delivered are non-conforming, pursuant to the standard of Article 42 of the CISG. To come to the first submission, claimants submit that generally the CISG is applicable to contracts for the sale of goods and to mixed contracts, such as the purchase collaboration and license agreement. According to Article 3, subparagraph 2, an exception is only made for mixed contracts with a preponderant non-sales element. However, this does not apply in the present case. And in any event, it is the party which relies on this exclusion that also bears the burden of proof. And these proceedings, respondents. Nevertheless, claimant is now going to outline that the exclusion of Article 3, subparagraph 2 does not apply in the present case. And to do so, we have to examine the preponderant part of the purchase collaboration and license agreement. And according to Article 8, subparagraph 3, in this regard, due consideration has to be given to all relevant circumstances of the agreement. And specifically, with regards to the preponderance test, the CISG Advisory Council opinion number 4 suggests two tests. First, an essential criterion examining the intent of the parties. And secondly, an economic value criterion examining the economic value of the obligations under the agreement. In this case, both tests lead to the same conclusion that the CISG is applicable, and both tests have also been affirmed in numerous court decisions, for example, by the Austrian Supreme Court in 2011. To begin with the first test with the essential criterion, I would respectfully like to turn the tribunal's attention to page 11 of the record. Is the tribunal with me?
Yes, I'm with you.
Before I go into further detail with the purchase collaboration and license agreement we can find on this page, I would like to point out that this agreement is based on a template which has been used in previous contracts already. And claimant has noted in these discussions that also the IP elements have to be taken into account, as the purchase collaboration and license agreement clearly is a mixed agreement. However, the specific amendments to this template have only been made with regard to the sale of goods part, and thus specifically reflect the intention of the parties.
But can I quickly interrupt you? I mean, I understand, and of course I have read your arguments, and I understand that there is but only one specific section in this agreement dealing with a purchase obligation. And I do have considerable problems to read therein the intention of the parties to have it governed as a purchase agreement, in particular as it reads, and please bear with me as well, in section 16.1, in case of a commercialization of the product. So it is not even clear that there ever will be a purchase and sale, or how would you actually see that?
Certainly. Claimant has to admit that clause 16 of this agreement is phrased in a conditional manner. However, it is our submission that this is only due to the circumstance that at the time of contract conclusion, the parties could not have stated that commercialization would certainly happen because the research and development was not finalized yet. And therefore, the only way to draft clause 16 was in a conditional manner. However, it was always the ultimate goal of both parties to reach commercialization and to sell a vaccine on the market, as claimant wanted to develop the vaccine to later sell it to prevent the pandemic. And also in respondent number 1's interest, there was a specific emphasis on clause 16, as clause 16 allows respondent number 1 to achieve 2 to 5% higher revenues through the sale of the HEK 294 cells.
Sorry when I interrupt you again, Mr. Klein. I mean, to have an entire intent of an agreement to be established on a clause which is under a condition, and on top, seeing that the agreement refers to the parties as licensee and licensor, you have to bring me a bit more. How and where do you see a further intent that this is in fact a purchase agreement, or respectively that a preponderant part, as per the test under the CISG, is on the basis of a purchase, of a sale, of a good, that would allow us to conclude that the CISG is the applicable substantive law?
Certainly. Leaving aside then clause 16, I would like to point out that the reason why the parties have kept the naming of licensee and licensor is for the sake of efficiency, because this contract was based on a template which had been used for a licensing agreement. However, in the wording of the contract, we can find, for example, that respondent number 1 refers to itself in the recitals as, and I quote, a contract manufacturing organization that produces and sells base materials. And furthermore, not only clause 16 deals with the sale of goods, but also clause 9.
I'm sorry, but wouldn't you agree that this is a description of what the licensor is doing? It has nothing to do with the relationship of the parties.
This is correct, of course. However, it shows that in this present agreement, respondent number 1 sees itself as a seller of goods, and not only of the goods under clause 16, but also of the goods under clause 9.2. Because certainly a license has been granted to claimant to use goods, but the license would be without any use without the GORAD-CAM vectors. Because only with the GORAD-CAM vectors, the vaccine can be developed. And this sale of the GORAD-CAM vectors, which are movable and tangible objects, and thus goods within the sense of the CISG, is also a sale of goods under this agreement. And again, points to the nature of this contract being a purchase agreement preponderantly. However, not only the attention of the parties shows this, but also the economic value. And for this—
Before we go to the economic value, sorry, I'm more convinced of the economic value than of the intention. So I would like to ask another question. You were referring to the tangible good of GORAD-CAM vectors, but can you actually explain to me how, in fact, title to this vector is transferred, which I understand is an essential element to qualify that vector as a good under the CISG?
Certainly. So the general definition of a good is a movable and tangible object, which applies to the GORAD-CAM vectors. And then we know from clause 9.2 that those vectors are to be delivered, and specifically that ownership is transferred of those vectors.
But it is exactly this vector that is a dispute, and of which, of course, also potentially Ross could claim that it has a certain entitlement to use it. So how can this good be transferred and full ownership be established?
It is our submission that the mere fact that the GORAD-CAM vectors are subject to a license does not change their nature. For example, if we take an example from our all-day lives, an aspirin pill, for example, is also subject to numerous patents. However, if we went into a pharmacy to buy a package of aspirin, nobody would question whether we concluded a sale of goods in that case. And therefore, it is our submission that the license is only a necessary add-on to this sale of goods of the GORAD-CAM vectors. And seeing that my time has already progressed, I would briefly touch upon the economic test and then move to the second issue. That's in line with the tribunal.
Before you move on, Mr. Klein, may I just ask you a question? Assuming that the CISG applies to the present agreement, to the present case, would the CISG govern all and every aspect of this contract, or including the licensing obligations and etc. assumed undertaken by the parties?
Claimant submits that this is the case, as Article 3, subparagraph 2 does indicate that not only pure agreements for the sale of goods are governed by the CISG, but also mixed agreements. And to come to the economic value test, I would like to outline 3 scenarios. First, the desired scenario that commercialization of a vaccine is reached. Then clause 16 would come into effect, outweighing all other obligations of this contract. The second scenario, that none of claimant's research is successful. Then we would be left with clause 9.2 and with the sale and delivery of the GORAD-CAM vectors. Only in the third scenario, where some of claimant's research is successful and some milestone payments are made, could potentially the non-sales part outweigh the sales part. However, bearing in mind that respondents bear the burden of proof in these proceedings for the exclusion of the CISG, it is our submission that from an economic point of view, only 1 out of 3 scenarios where a risk may occur is not sufficient. And with this, I would like to move to the second submission that the GORAD-CAM vectors respondent number 1 delivered are non-conforming pursuant to the standard.
I still have one question. Can you convince us further by probably pointing out some legal authorities that have, in similar circumstances of a license agreement, still concluded that the purchase element is the preponderant one?
For example, I could direct you to the corporate web solutions case, where also a license has been sold in exchange for a one-time payment, and this scenario has been governed by the CISG. Also, another example could be numerous software agreements, as software is recently considered also as a good under the CISG and is a right in a sense. To come to the second submission, and if I may in this regard request an additional 2 minutes, perhaps even, to elaborate further on that.
Yeah, this is granted.
Thank you very much. I would first like to begin by addressing the standard of Article 42 of the CISG, as this has already been raised by my co-counsel and also by this tribunal. It is claimant's submission that Article 42 of the CISG is invoked if there is already any claim which could infringe the use of the goods.
Counsel, I have a question for you on that. Thank you. And I'm sorry to have interrupted you. The tribunal, however, does understand what 42 says, but I have a fundamental question for you relating to the issue of claim. What law will determine if in fact a claim has been made?
Claimants submit that Article 42 of the CISG has an autonomous understanding of what a claim is. And pursuant to this very specific understanding, which I'm now going to elaborate on, a claim has been made in this case, as the rationale of Article 42 is, to put it bluntly, to protect the buyer from purchasing a lawsuit. Therefore, any threat of legal proceedings is sufficient to invoke uncertainty for the buyer and thus calls for the protection of Article 42.
But Mr. Klein, sorry for the interruption. Exactly in that regard, I do have a problem because I don't see where a specific threat for a litigation has been raised. I see some statements, I see correspondence exchange, but where do you see this threat?
Certainly. To outline this, for example, I can point you to the fact that Ross Pharmaceuticals has a vigorous policy of enforcing their IP rights. And Ross Pharmaceuticals is a direct competitor of claimant who is about to commercialize its vaccine, as they already are in their phase 3 clinical trial. And it would only amount to a common business strategy to approach the competitor at a point in time where the inventory is at its highest, but the cash flow is at its lowest. Therefore, claimant submits that in any event, now there's a threat bigger than ever of Ross Pharmaceuticals approaching claimant. And the threat is further underlined by the fact that the Ross agreement, also on basis of merits, extends to the purchase collaboration and license agreement. And seeing that my time is already about to run out, I think I have to conclude my submissions, if not the tribunal is willing.
Yes, please do so.
Thank you very much.
But if you need another 1 or 2 minutes, of course, that is granted. We have interrupted you quite frequently, so please.
Oh, thank you very much. And then indeed, I would like to elaborate on the fact that the Ross agreement does overlap also from a merits point of view with the purchase collaboration and license agreement. Generally, this is not even a requirement under Article 42. For example, the Austrian Supreme Court in 2006 in the blank CDs case held that also unjustified claims are sufficient under Article 42, as to fend them off is already sufficient burden for the buyer.
But Mr. Klein, now I have to interrupt you because I think this is now a rather conflicting statement you're making, because in the joinder, you have actually raised your voice and said there is no overlap. And now you're actually trying to convince me that because there is an overlap, there is also the potential threat of a claim.
Certainly, claimant specifically relies on the fact that a claim has been made, and this is sufficient to invoke Article 42 of the CISG. However, to outline the risk we have and to show that the threshold of a claim is easily made and is even exceeded in this case, only by judging from the record we have right now, and without a further joinder of Ross Pharmaceuticals, we can see on this basis already that the claim of Ross Pharmaceuticals has merit to it. And to outline this further, I would like to point to a scientific, or perhaps to the procedure order number 2, if this may be my last statement. And specifically, I would like to point to page 55 of the record. There I'm referring to paragraph 20 in the middle of the page and to the sentence which begins with the word "at the time." And I quote, "At the time, Ross Pharmaceuticals had no specific field in mind and was not engaged in any particular research for which it planned to use the viral vector. Thus, Ross Pharmaceuticals drafted its proposal for the clause as broad as possible, indicating that there is a high likelihood of the Ross agreement conflicting with the purchase, collaboration, and license agreement. And with this, I would like to conclude my submissions by stating that respondent number 1 has breached their contract pursuant to Article 42 of the CISG.
Thank you very much. Any follow-up questions by my co-arbitrators before we go on to respondent for the merits pleading?
I have nothing, thank you.
You, Lauro?
I have nothing either, thank you.
Thank you very much. So with that, we immediately go to Mr. Tan on respondent side for the merits pleading. Please, the floor is yours.
Members of the tribunal, good evening from Singapore. Earlier, the claimant indicated that the commercialization of the vaccine would be affected because of a claim by Ross Pharmaceuticals. Here we will show why the claim by Ross Pharmaceuticals is entirely baseless. And in this light, I make 2 submissions. First, the CISG does not govern the PCLA. And even if the CISG applied, Article 42 of the CISG has not been breached. Turning to my first submission, we are in agreement with the claimant that the main issue in contention before this tribunal is whether the preponderant part of the contract lies with the non-sale licensing obligations. We also do not dispute the preponderance test and the 2 elements to it, that is the essential criterion test as well as the economic value test. Now I'll first address the parties' intentions. Here we say that what is indispensable under this contract is the very crucial license that allows for the commercialization of the vaccine. Earlier, Ms. Noterbas queried the claimant on the addition of one specific section that is a purchase obligation. And indeed, this is an additional purchase obligation that was tagged on to a licensing agreement. It was the claimant themselves who had insisted for such a template to be adopted. Now, to prove this point, members of the tribunal, if you can turn with me to page 31 of the record. My apologies, page 30 of the record. And if this tribunal is with me, at paragraph 7, starting from the second line, you will see that the claimant was in particular of the view that the model would not sufficiently take into account the IP element involved, and a template for collaboration and licensing agreements was adopted. Members of the tribunal, this is perhaps telling that the claimants did not attach a licensing obligation to the initial standard manufacturing template, but rather they requested for a licensing template, and it was only and the additional purchase obligations was only subsequently attached as an afterthought. Now here, we would further point to a second factor that would show the preponderance of the contract being that of the license.
Can I, before you continue, excuse me, Mr. Ton, I understand you're heavily fighting for your position, and I do respect that, but can you probably explain to us why you're actually opposing the application of the CISG, the CISG, as you would say in English? is there anything you don't like about it? Would it weaken your position, or why are you actually opposing the application of the CISG?
Specifically, we note, Ms. Notabes, there are in fact warranty clauses under this contract, specifically at clause 11, which is found on page 15 of the record. But rather than suing under the warranties that are available under this contract, what the claimant is now seeking to do is to allege a breach of Article 42, and they submit that the standard under Article 42 is lower. And we say that this is a matter of cherry-picking the provisions under the CISG. And here, as Ms. Notabes had earlier queried the claimant on the use of the words licensor and licensee, it is not simply these labels that show that the substance of the contract lies with the licensing component. In fact, at page 15, the warranty clauses, if this tribunal is with me.
Yes, I'm with you.
Thank you. Under the warranty clauses, they all relate to the license, but none of them, for example, talk about the quality of the goods or whether the goods are in fact fit for purpose. And so even on the contractual wording itself, it shows that parties had always intended for this contract to protect the legitimate expectations of their IP rights.
Mr. Ton, just also a general question that I can better follow your arguments. You very often refer to the intention of the parties. Can you probably explain to me what the basis for your interpretation, on which principles are you actually interpreting the agreement? Because I see on the one hand, you emphasize, as I have just said, the intent of the parties. On the other hand, where it fits your reasoning, you very much like us to focus on the wording.
Ms. Notabes, we would note that what we rely on, the basis, is Article 4, subsection 2 of the UNODOA principles. And this is because the Nubian law governs the contract. And under Article 4, subsection 2, if the parties have not expressed any common intention as to the wording, then we must resort to an objective, reasonable person's interpretation of these clauses. And here we submit. Yes,
and also in that regard, can you simply explain to me what then the order of priority is, given in this reasonable interpretation of a contract? The wording definitely still plays a role, but is it to give in priority over the intent or vice versa? What is your position in that regard?
Ms. Notabes, in fact, Article 4, subsection 3 of the UNODOA principles requires us to take into account all relevant circumstances, including the pre-contractual negotiations, as well as the wording of the contract. Now, we do not say that one weighs over the other, but the wording itself should be seen as a manifestation of the parties' intentions. And here, we would say that therefore, the additional purchase obligations that the claimant has extensively relied on does not show that the preponderant part of this contract lies with the sale obligations. And this is because it was only because of how important the license was that this obligation could be added under this contract, and the claimant then accepted this obligation. And so I turn now to the economic value analysis, which the claimant has similarly proffered. Now, the claimant has shown this tribunal that there are in fact 3 scenarios which we need to be aware of. But regardless of these scenarios, an economic value analysis in the present case is simply unreliable. And I say this for one simple reason, and that is because the entire economic value analysis that the claimant has proffered is based on one very critical assumption. And that assumption is that each vaccine dose is priced at 25 euros per dose. Now, if I can invite this tribunal to turn with me to page 53 of the record. At paragraph 6, you will see at paragraph 6 that the price per vaccine can be set between 20 to 40 euros. Now, what the claimant has crucially omitted to mention is that above the price of 35 euros, it is the value of the license that outweighs the value of the sale obligations. And the point of this, members of the tribunal, is that an economic value analysis can be gamed and is manipulable, and therefore we should simply look at the parties' intentions, which point towards the preponderance of the license. Moving to my next submission, on the breach of Article 42 of the CISG. It is undisputed between the parties that the claimant needs to prove that a claim has been asserted by a third party and that the seller knew or could not have been unaware of these third-party claim. Now, as the claimant has only addressed the first requirement, I will do so. Now, the claimant has earlier raised the concern that there is an imminent threat of legal proceedings by Ross Pharmaceuticals. Specifically, members of the tribunal, we say that that is not founded on the facts. In fact, if you would turn with me to page 35 of the record, and I'm referring to the third substantial paragraph, which starts with the words, "in my view." It is in the interest of both parties to solve the divergence in interpretation in an amicable way outside of the courts. And this email was dated.
I have a question, Mr. Ten. Excuse me, I'm sorry. I apologize for interrupting you. Is on this precise argument that you're raising. Is your argument that Article 42 CISG does not encompass obviously unfounded or frivolous claims?
Professor
Are there any
Gama?
authorities? Yes. Yeah. And
to-
if so, are there any authorities that support your argument?
Now we say that, perhaps to clarify the position, there are in fact two distinct inquiries which we have to look at for a claim. Now the first relates to how that claim must manifest, whether it has to be in the form of actual legal proceedings or whether an email would suffice. And the second inquiry, as Professor Gama has pointed out, relates to the strength of the claim that is required to breach Article 42. And here we say, on the first inquiry, relating to how that claim must manifest, a simple email in which Ross Pharmaceutical has stated that it intends to settle the dispute amicably outside of the courts does not suffice to show that a claim has been asserted by a third party. And this was in fact supported by Professor Seidoff in his commentary to the conformity of goods and documents. Now, we say
But Mr.
that
Ton, I'm sorry to interrupt you, but is your position that on the basis of the exchanges of the parties, of all what we know, press releases, etc., there is really truly no threat that Ross Pharmaceutical could raise a claim? Is that your position?
Yes, that is correct, Ms. Notabes. That is our position.
But I have a bit of problem to align that with your position that you want to join Ross to these proceedings, because if you are totally relaxed that they're never going to raise a claim, why would you have an interest in joining them?
Ms. Notabes, we note that in terms of the strength of the claim, we would have to join Ross Pharmaceuticals in order to marshal all the facts before the tribunal during the evidentiary hearing to conclusively determine the scope of the license, as was elaborated earlier on by my co-counsel, Ms. Low. But even if this tribunal is not minded to order the joinder, we would say that on the facts available in the record, we can show that Ross Pharmaceuticals' claim is entirely baseless and that there is no imminent threat of legal proceedings. And this is because, as the claimant has pointed out, Ross Pharmaceuticals has a policy of vigorously enforcing its IP rights. But yet, after 2 years, they have not shown any intention to bring this claim. And first, members of the tribunal, I note my time, if I may just have 2 minutes to conclude my submissions.
Of course, it's granted. Thank you.
Thank you. Now here, we would turn to the strength of the claim that is required to breach Article 42. Earlier, the claimant raised the case, the Austrian Supreme Court decision in CD Media, to say that even unjustified claims would suffice to breach Article 42. Now we beg to differ, and in fact, the CISG Secretariat commentary has stated that although an unjustified claim can trigger the application of Article 42, the burden shifts to the seller to show that this claim is frivolous. And on the facts of this case, at page 55 of the record, at paragraph 20, I will not trouble this tribunal to turn to that in the interest of time, but this was pointed out by the claimant's counsel earlier on. And in fact, the parties have shown an intention that related infectious diseases should be interpreted to only mean diseases which are endemic to developing countries. And so there is a geographical limitation to what parties had intended. It is not all respiratory infectious diseases. And as we know, COVID-19 is a global pandemic. It is not simply confined and endemic to a developing country. For this reason, yes, Ms. Notabes.
Thank you. And I'm sorry that I interrupt again, but you made some interesting remarks at the end. I'm sure you can place yourself for a moment in a position of a claimant who wants to produce a vaccination and wants to start selling the vaccination. That's the entire purpose of entering into such an agreement. Wouldn't you agree with me that the mere fact that there are statements out by Ross, alleging that they are also entitled to use this vector for respiratory diseases and not just malaria is a threat and actually could have a strong impact on business opportunities of claimant. And as such also is sufficient enough, to probably invoke the CISG provision that is at stake.
Ms. Notabes, we would say that here, principally, the claim is frivolous and the respondents have the discretion on whether to inform the buyer of this. It is frivolous and baseless, and therefore no such duty to inform arises. But in any case, if this tribunal wishes to have the submissions of Ross Pharmaceuticals, then perhaps a joinder should be ordered to conclusively determine the scope of the license in the present case. Members of the tribunal, that concludes my submissions. And unless I can take any further questions.
Thank you very much. You have not exactly responded to my last question, because the question is not so much what the parties can do and how they can educate themselves in the course of this arbitration or a separate arbitration or in a, let's say, in a manner where Ross is actually joined to this arbitration. The question is whether the mere fact that Ross makes such statements, also publicly, whether the mere fact that they could continue making even stronger statements would not just be an impediment for claimants' business in the future. And as such, of course, affects, the entitle and its unrestricted use of the goods that it has purchased under this agreement.
Ms. Notabes, the only way to stop Ross Pharmaceuticals from making such statements is perhaps the joinder mechanism, because that would conclusively bind them to the decision and show that Ross Pharmaceuticals' claim is frivolous, and so no more statements can be made by Ross Pharmaceuticals in that light.
Thank you.
Thank you.
Any questions, Anne? Yes, please.
Yes, I have one. Mr. Tong, you've talked about frivolous, you've talked about baseless. I want to ask you the same question that I asked the claimant. What law is going to determine whether or not the claim is frivolous or baseless? What do we look to?
Ms. Robertson, on the assumption that the CISG applies in the present case, then we would say that the relevant basis for interpreting the party's intentions would be similarly Article 8, subsection 2. And that looks at the common intention of the parties. And if that is not found, then we look at the subjective intentions of the parties. And here it is shown that parties had only intended for related to be defined as diseases which are endemic to developing countries.
Well, now let me take this one step further then. What law governs the contract between your client and Ross?
Between my client and Ross, the governing law for the contract is the Unidroit principles. And similarly, in the Unidroit principles, we have Article 4, subsection 2, which is identical to the provision in the CISG. And so the interpretive principles are the same under both laws.
When you say it's identical to the CISG, what provision of the CISG are you making reference to?
Specifically, I'm comparing Article 4, subsection 2 of the Unidroit principles and Article 8, subsection 2 of the CISG.
But if in fact we have a dispute between Ross and your client regarding Ross's entitlement, and we are interpreting that contract, what law are we using to interpret that contract?
Because the Ross agreement is a standard licensing agreement, then the Unidroit principles would apply, Ms. Robertson.
So we would use unidroit to determine if, in fact, ultimately the claim was baseless or frivolous. Do you agree with that statement?
That is correct, Ms. Robertson.
Okay. Thank you, counsel.
Thank you.
Lauro, do you have any follow-up questions?
I do not have any further questions. Thank you very much.
Okay. As we, in the essence of time, have not done the rebuttal on the procedural issues, I definitely want to do that here on the merits issue. And if time even allows us, we may go back to the procedural issues, challenging the parties' flexibility in the argumentation line further. So, claimant, do you want to rebut on respondents' merits pleadings?
Yes, please. Honorable members of this tribunal, I would like to begin with the first part of respondent submission with the intentions and to outline the intention of the parties to conclude a non-sales agreement. It was opposing counsel who pointed us only to the standard provisions of the contract, which simply for the sake of efficiency have been taken from the template of a licensing agreement. But the specific changes which have been made and which point to the intention to conclude a sales agreement have been omitted. And with respect to the economic test, I would like to stress that opposing counsel directed us only to the third scenario of clause 16 kicking in. However, I also mentioned that the one certain scenario we have is that clause 9.2 would come into effect. And we know from the appendix that the 2.5 million euros paid in clause 9.2 relate only to the sale of GORAD-CAM vectors, and thus to a sale of goods. And therefore, on the first submission of respondents, we would disagree respectfully and outline that the CISG remains to be applicable. And with respect to the second submission, I would like to begin with the question posed by Madam Arbitrator, Mrs. Robertson, and I would like to address once more the question of the applicable law. If we did not take an autonomous understanding of what a claim is in the sense of the CISG, we would come exactly to this problem that we would have to look at all the different contracts which might infringe upon a contract governed by the CISG, and they would all be governed by different laws and thus pose perhaps different standards as to how claims are to be interpreted. And this would certainly lead to a non-conclusive answer as to what a claim is and as to how the CISG is to be interpreted. And therefore, claimants stick with their argumentation that what a claim is has to be interpreted autonomously under the CISG and in accordance with the rationale of that provision. And therefore, I would like to stress once more that the rationale is to protect the buyer from purchasing a lawsuit. And specifically, a claim is sufficient, but a right is also sufficient, but not necessary. And opposing counsel.
Yes, please conclude, and then I will ask my question.
Thank you very much. Opposing counsel has tried to exempt itself from liability by suggesting the joinder and by determining the merits of a claim. However, as this is only sufficient and only necessary for the right and not for the claim, we have to stick with the threat we have in these proceedings. And opposing counsel pointed us to the email on page 35 of the record and outlined that this email was sent in December 2018 and suggests an amicable solution outside the courts. However, we know as time flies by that this amicable solution has not been achieved, and therefore the threat remains that Ross might approach claimant. And therefore, to conclude on my rebuttal, I would like to outline again that the threat of which the buyer is supposed to be protected under Article 42 is existent, and therefore the goods respondent number 1 delivered are non-conforming.
Follow most of your arguments, but not the one where you are still opposing a joinder, because the joinder would actually bring the clarity on whether or not Ross would actually raise a claim or whether its position is really just, to better his deal that he has initially probably entered into with respondent 2. So can you elaborate again on the arguments why the joinder would not be the solution, to also clarifying whether there is a threat of claim and if is that a defective good under the CISG?
Certainly. Claimant has to acknowledge that a joinder of Ross Pharmaceuticals would, if time was not of the essence, be a great solution to determine all questions and find conclusive answers to all problems, and even determine whether a right in the sense of Article 42 of Ross Pharmaceuticals exists. However, since we have proceedings where the commercialization of a vaccine has to occur as fast as possible to be helpful in this global pandemic, we only rely on the claim in the sense of Article 42 to be able to achieve legal certainty as fast as possible. And this is specifically what would be hindered by a joinder, as it would prolong the proceedings.
If there are no further questions from my co-arbitrators, I would like to give the floor again to Respondents' Counsel for the third rebuttal.
Thank you. Earlier, the Claimants' Counsel first referred to the intention of the parties under the issue 3. Now, and he highlighted that standard provisions were taken and therefore should not be given great weight too. However, members of the tribunal, these are contractual provisions which must nonetheless be interpreted. And in any event, it is perhaps telling that the claimant did not adopt the standard manufacturing contract and subsequently added a licensing obligation. But rather, what they did was to adopt this standard licensing template before adding an additional purchase obligation. Now, this clearly shows that they did not value the sale obligations under the contract. The claimant next turned to the economic
Mr.
value.
Pan, can you, yeah, exactly, with regard to the economic value, but you would have to agree that if there is a commercialization and the purchase element would become the preponderant part.
No, Ms. Notterbest. In fact, even if there is commercialization, if the price of the vaccine is sold at 35 euros per dose, it is the value of the license that outweighs the value of the goods.
And
now,
if it's increased?
If it's increased even further, then the value of the license becomes way more than the goods.
Thanks.
Now, on the second submission, claimant raised that the governing law of the contract, we should interpret claims in an autonomous sense, but this cannot be the case. The Ross Agreement was concluded in 2014, and it is clear that the CISG does not govern that agreement. And so in order to interpret the words related and how a claim should be defined, it must be interpreted in accordance with the Nubian law, which is a verbatim adoption of the UNIDROIT principles. And on the claimant's final issue on joinder, now Ms. Notterbest had earlier queried on why the claimants have rejected joinder in the first place. And we say here that it is in fact in the interest of the claimants to join Ross Pharmaceuticals. It is not in the respondents' interest because we know that Ross Pharmaceuticals would likely bring their own sets of submissions on what the definition of related is. Rather, we are joining them so that an injunction can be sought against them, and so the decision is binding and conclusive, and all three parties will end up being happy.
Mr. Tan, I have a question. Sorry, I would like to come back to your previous argument on the interpretation on how to interpret claim under the present dispute. And if I understood you correctly, we should not employ an autonomous interpretation of claim under the CSG for the purpose of applying Article 42. And I would just like you to develop further on your argument in that sense, because I'm not very convinced about it. Thank you very much.
Perhaps, Professor Gama, the point is we do acknowledge that the CISG has an autonomous character, but it does not define the definition of claim. And so we say that in order to interpret the relevant provisions under the Ross Agreement, to interpret the words related, we must look at the UNIDROIT principles. But in terms of the definition of a claim, we highlight that the rationale for having a claim to be defined in the sense of actual legal proceedings requires us to take an autonomous interpretation. And so we agree with the claimants insofar as Article 42 of the CISG is concerned. But to clarify my position, It is only the word related that must be interpreted in accordance with the unidroit principles. I hope that clarifies it.
It does. Thank you very much.
Thank you.
Thank you very much. I'm also glad to see that in this rebuttal and rebuttal, we have also addressed and come back on some of the procedural issues. So I consider that to be sufficiently pleaded, except for the hearing part. And here I would not miss the opportunity, as we still have a couple of minutes time, to give time for a small rebuttal, and that would be on respondent.
Thank you, Ms. Notter-Bass. Here on the second issue on a remote hearing, we note that earlier Ms. Notter-Bass questioned the counsel for claimant on how the lack of an intention can prove the common intention as to the parties on Article 4 of the unidroit principles. And here we say, referring this tribunal to page 57 of the record, at paragraph 32, the last line of paragraph 32, indeed, the issue of virtual hearings was not discussed, and so it cannot be that this common intention of the parties is the relevant method for interpreting the clause. Rather, we would have to fall back on the reasonable person's shoes in order to understand that sentence in clause 14.1. And seeing that hearings does not distinguish between a physical and a remote hearing, it can be taken that parties had intended that any hearing would be held in Vindobona or in the city where the respondents have its place of business. And this concludes my rebuttal. Thank you very much.
Is there any wish for a rebuttal on claimant side?
Yes, please. Thank you. I would like to rebut to this statement in two ways. First of all, if respondents acknowledge that the clause is ambiguous and it cannot be conclusively determined what the intentions were, this clause needs to be interpreted contra preferentum, in this case against respondents who provided the template for that clause. And furthermore, even if one would take a restrictionism approach, assuming that the parties did want to stipulate for in-person hearings, this tribunal should also consider the significant change of circumstances that has happened since the conclusion of the agreement in 2019, where no pandemic was in sight. Thank you.
Ms. Leek, I have just one question. Isn't there a reasonable third-party standard one that you would have to apply given the circumstances of entering into the agreement? How could this change circumstances unless you would now start arguing force majeure hardship provisions with regard to interpretation of the arbitration agreement? How would that play a role?
Actually, it would be my submission that this tribunal could at least apply or rely on the rationale of, for example, Article 79 of the CISG that is concerned with hardship situations. The rationale of that provision is to exclude the parties of the contract from the obligation on the contract, just as we would in this case exclude the parties from their obligation to consider an in-person hearing, So we could apply this rationale to the arbitration agreement as well. Specifically, as in Danubia and the other respective countries, the CISG can also be applied to the interpretation of the arbitration agreement.
Thank you. We are soon running out of time, but nonetheless, if my co-arbitrators have any follow-up question, please.
I have none. Thank you very much.
And you, Lauro?
I have none either. Thank you.
Then I hope that both parties had sufficient and ample opportunity to plead their case. Is there anything you want to say here? Is there any objections you want to raise regarding the way this tribunal has conducted this oral hearing?
Not from claimant side, I think.
Respondent side?
Also not from the respondents. Thank you.
Then I would like to thank you very much for this constructive, efficient, and well-prepared oral hearing. And with that, I would close this hearing. Thank you so much and have a wonderful day.
Very much.
Thank you.
Thank you.